Everything has been commingled up to now. Okay, the first we're going, oh, this is a marvelous book. It's called The Law of Trusts and Trustees. It is by two Bogarts. I don't see. Is one alive?
Yeah.
One is still alive. Oh my God, that's wonderful. Well, the original must be his son, I guess.
They're brothers.
Brothers. I presume that they were sons. The original was written in 1931. Perfect timing. They had a lot of world of worth of information there. And it's basically upon normal, average, ordinary trusts. And every now and then they throw something in regarding history, government, etc. Okay, on page 4, section 1, he names they name the trust parties. Okay, there is a settler of a trust, and he is the person who intentionally causes it to come into existence. There we have the founding fathers. Okay, the trustee is the person who holds the property for the benefit of another. Okay, it's the government's duty to take care of our property for our benefit. The beneficiary or cestui trust is the person for whose benefit the trust property is held by the trustee. That's us. Well, I don't like to call that us. I like to call us the heir, because I don't want any confusion between their 14th Amendment beneficiary and me. So I'm an heir, because this shows that there are heirs in here. Posterity is an heir. There's, we go into the trust and trust rights and duties, okay, and he defines for the benefit of the cestui, and we, cestui trust means beneficiary, and it goes into the duties of the trustees.
Where is this?
Oh, this is on page 6. This is superficial stuff that we're going through temporarily, okay? He goes into the classification of trusts, okay? On page 7, trusts are usually classified into two main groups, express trusts or implied trusts. We really don't want to get into the quagmire of federal law. Because it's just like quicksand. Quagmire, it's like quicksand. On page 264, remember we discussed the Catholic Church. Section 37, Religious Corporation Soul. Some slight remnants of the doctrine of corporation soul still exist in American law. In the English law, the king, certain church officials, and other occupants of public positions, were treated as having a separate entity as officials and were called corporations sole. The king, the sovereign. Could it possibly be that our corporate capacity of the United States government is a corporation sole? Yes. There's so much in Bogart that I have to search for it. I bought these books for $1 a piece. Let's buy that, you know, and I thought I had a complete set, but number 4 was missing. So I think I paid $5 or $6 for the whole set of Bogart's Trust, and it sat on my shelves for almost 2 years. And I was about ready to give them away, going, "Why, I don't know why I'd ever used them." I wasn't interested in trusts, at least I didn't think so, until I found this, and then Bogart came up with some wonderful things. Okay, next page, 546. Oh, selection of trustee who cannot be sued. Let's go down to the marked line. It says, neither the Crown in England, the United States, nor a state can be sued without its consent. What? Well, now we have the trustees. Now I can show you that they're trustees. Okay, they bring in the words United States, Crown of England, a trustee who cannot be sued. Okay, and the United States claims that they cannot be sued unless they give their consent. Well, that's kind of, you can read that later. California statute preventing. Oh, here's over on the right-hand corner, bottom 547. A California statute prohibiting gifts by will to the United States among other corporations is not unconstitutional on the ground that it permits gifts to the state of California and its subdivisions, U.S. versus Burness, 1950. Here we have a mention of the United States in its corporate capacity. Okay, so when, you know, the question in my mind comes up quite often is just when did they start using their corporate capacity, because they weren't always a corporation. They didn't start out that way. The words don't say in God we incorporate, the words say in God we trust. Okay? So when do they start exercising their corporate capacity, and is it a de facto corporation or a de jure corporation? In the state of California, in most states, you cannot be a de facto corporation. I don't see evidence that they are de jure either, except for this grant right here. Page 556 is on reservations. It is common that the settlor is himself a trustee, either by his own declaration or that fact, or by reason of a conveyance by himself to himself and others as trustees, or by buying land in his name as trustee for another. If the settlor reserves no powers to himself expressly in the trust instrument, he will, as settlor, have only sentimental interest in the administration of the trust. That is why there is a reservation in the Fifth Amendment and reserved to the people, so that there is no sentimental interest. The reservation, remember, is important. That I told you before, it had to have a reservation. Isn't this beginning to look beautiful? Got to keep those reservations. Everything falls into line under these estate laws. And hence his position as trustee does not, in the usual case, give him a dignity of legal interest. Duality? Thank you. Duality, yeah, my eyes are getting a little tired from reading. Page 557. Municipal corporations as trustees, in that it goes into the towns, cities, villages, school districts, and other governmental agencies are created by the state. Okay? Down at the bottom, when you see a little mark where I say cypress, cypre, okay? We're going to get into cypre. It's important. Are we missing a page? No, I guess not. Okay, we're going to go back here. Cypre, I'll see if I can. If such power is lacking, there will be vacancy in the trusteeship, and the court will appoint a trustee. This is cypre, okay? But the validity of the instrument of creation will not be questioned, okay? I know it's vague so far. In the groups of governmental, eleemosynary, or educational charitable trusts is on the next page. Got to find where we can clarify this. A municipal corporation has no power to accept and carry on a private trust or a charitable trust for religious purposes. You notice it added quickly, for religious purposes. It didn't say or charitable trust, period. It says charitable trust for religious purposes. The 14th Amendment is a charitable trust. It establishes a... Mm-hmm.
That's why everything's in a private corporation. Social Security.
Yeah. Well. Okay. The way I see it is the Federal Reserve Act created the trust fund. Okay. It established the trust fund. It actually did establish even maybe a lesser estate than the 14th Amendment, a non-freehold estate. The Social Security Act itself created possibilities for beneficiaries to draw from the trust fund. That's where you separate the gold and silver from the Federal Reserve note. Now you're a beneficiary over here under your main principles, collecting money that is for the beneficiaries of a 14th Amendment estate and trust. So we're going to get into this further. I want to see pray when I can. I wish I hadn't brought that up so soon. On page 560. In the early law, the position was taken that a corporation could not hold to uses or be a trustee on account of its impersonal, artificial character. It had no conscience. Equity could not act on it by a decree strictly in personam. This objection was overcome as early as the middle of the 18th century. This is when they started to attack the mortmain statutes. Okay? In modern times, corporate trustees are probably more common than individual trustees. And the trust company, the professional corporate trustee, assumes an ever larger position in trust management. Boy, it sure has. It is obvious that the charter or incorporation papers of a corporation, considered in the light of the statutes and constitution of a state, will determine the capacity of a corporation to administer as trust. Let's turn pages. Let's go on. The Law of Trustees and Trust by Bogert, again, Volume 2. Now we get into federal income tax, duty to make a return.
Where is it? 143?
143. Section 264. Trustees are under a duty to make a return of income of the trust if its net income was $100 a year or over, or its gross income $600 a year or more, if the beneficiary is a non-resident alien. Footnote 39. Please go down to footnote 39, letter C. Do you see on the side there where I have written? This was valid in 1910. Any fiduciary required to make a return under this chapter shall be subject to all the provisions of law which apply to individuals. What law applied to individuals in 1910 with the duty to make a return? When was the 16th so-called amendment passed?
1913.
No, 1914 wasn't it?
It was after 1910.
Ah. No, you're right, so it was 1913, yeah.
Well, it never was ratified, but supposedly in 19...
Well, even if it was or if it wasn't, here we're discussing that individuals are supposed to have made a return prior to the supposed enactment of an individual income tax return.
Corporations.
This was for trusts. What they did was they created the laws that were going to apply to us before they applied it to us, and they applied it to the trusts that were in existence. They attacked the existing trust at that time in order to break them down so that it could eventually come around and be applied to us under what they've already established.
Devious, devious, devious.
Ah, the plot thickens. Yes, yes, yes. We go on. Okay, returns. If the return is made on the basis of the calendar year, it must be made by April 15th. The laws were already established before they created them toward us. Wasn't that generous of them? Here down here it says, if he makes oath that he has sufficient knowledge to the affairs of the trust to enable him to make the return, and that the return is correct to the best of his knowledge and belief. Here we have your statement of perjury. Now, trusts were attacked in court openly from what I gather from about 1893 to about 1925, even further on. They were attacked in order to destroy the integrity of our trust, to chip away at the building blocks, the foundation of this country, to get through to this. Now on page 164, I don't know if any of you have ever received letters from the Internal Revenue Service or the Social Security Department saying that something about a right to receive. If you probably would skim right over it, okay? Everything's all about a right to receive. When they use the words right to receive, there is a trust involved. And on 164, there's a little line there is talking about the beneficiary has a right to receive. And so does page 165. If you ever see that wording in a letter that you receive, they just informed you of a trust. They just informed you. They didn't use the word, but they just informed you. That's how they inform you deviously, okay? Under the table, underhand. Now, according to Bogert, on page 216, it starts, there was a case in 1925, Frick v. Commonwealth of Pennsylvania, and says in the decision in Frick v. Pennsylvania, it put an end to all this and placed property taxes and inheritance taxes on essentially the same basis, so far as the power to tax with reference to chattels were concerned. Now, I've read this court case, and I can't find it, but I believe truly that this man knows exactly what he talks about, and that inheritance taxes and property taxes were placed on the same basis and same level. Like I said, I've read the case, and I keep scratching my head going, now, how did they figure that one out? Obviously, it's got to be in there somehow and somewhere.
Probably the wording. Some wording.
Oh, I'm pretty good at figuring out wording. But have you read it? You haven't read it? I've read it. And I take this man's word for it, because this gentleman or these gentlemen knew a tremendous amount, and they gave a tremendous amount of information on trust, and they evidently saw it. I believe it's there. I just haven't figured out exactly how it's worded in the Frick case to have property taxes and inheritance taxes placed on the same, essentially on the same basis. Okay, so now here we have the income tax and the presumably the inheritance tax going like this. We're now on the same basis. So this is how they brought all the trust stuff into our supposed income tax. Okay, do we get it? The couple paragraphs down, as will be shown later, the estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Some extent. We're still on the same page, 217. Okay, the last paragraph. The estates of aliens and non-resident citizens are to some extent subject to the federal estate tax. Now, what if you were a non-resident alien in this country? You know, a lot of people are attempting to use the non-resident alien argument. And, you know, are you really a non-resident alien? Are you, what the heck are we? Are we really sovereign citizens? Are we heirs? You know, I'm an heir. But a lot of people are using the non-resident alien argument, and it may or may not be exactly what they think it is, because I have found different wording or a different way of writing or saying non-resident alien. And I don't think it means non-resident alien, but then I may be wrong. We'll be reading that shortly. I'll let you determine exactly what it means. News at 11. Gift tax, page 306. The federal gift tax was incorporated into the Revenue Act of 1924, but was eliminated in the revision of 1926. For 6 years, there was no such federal tax. But in 1932, this feature of the tax statute was reinstated, and it is to be found in the present statute in detail and elaborate form, having been amended from time to time between 1932 and 1951. Well, my gosh, they took it out for 6 years from 1924 to 1932. This must be important. Okay, the gift tax stuff. Why would they have taken the gift tax stuff out for 6 years and then put it back in around about the time the Social Security Act came in? Does that seem to make a question arise in your mind? Gift tax taken out for 6 years? If it's an estate, if this is an estate and the 14th Amendment creates an estate, what is the income tax? Down at the bottom, let's see. The statute applies to gifts of property of all kinds, whether the gift is by trust or otherwise, and is direct or indirect. If the transfer is a citizen or resident alien, the Act applies to transfers of any of his property. But if he is a non-resident alien, it governs only as to property situated within the United States. Couple bells go off? A bell go off? Any bell go off?
Try to be dinging.
A little ding, just a little ding? Did you catch a little word such as the words situated within the United States? Ever hear that before? The tax is not imposed on the recipient of the property by the donee. On the contrary, the tax is primary and personal. Liability of the donor is an excise upon his act of making the transfer, is measured by the value of the property passing from the donor. Any more bells go off? Taxation of charitable trust. Now we're going to go into charitable trusts, folks. Okay, we just touched upon taxation as found under trusts. Okay, and it's bringing out little bells and little catch things, that keep getting your attention. Like, oh, what was that? Did you see that shadow flick by? Was it something truly there? Okay, we want to find out if these little shadows flicking by us are in our imagination or if they actually exist.
Can't wait to see when it says voluntary compliance.
Oh, it's voluntary.
Yeah.
Sure. Oh, it's voluntary. You volunteer to take under the will. Yeah. You made that election with voluntarily. Now, charitable trusts. Let's see. The preamble of the statute. We're on page 418 of Bogert's. The preamble of the statute of charitable uses gave illustrations of current charitable trust, but was not intended to set forth an exhaustive list of trust. Going further on, showing the kinds of objects in which the 17th century were regarded as social benefit, but surely could not reasonably be considered as a measure of 20th century social policies or purposes. Do you want to bet? Do you want to bet? Let's see. Oh, by the way, just to go off side, the statute of uses, not charitable uses, I don't know about it, but the statute of uses in England was repealed in 1925. Great timing. Them and us. 1925 was repealed. This is a statute of 43 Elizabeth C4, made in 1601. Okay, now this is a long time before the revolution in our country. Here the founding fathers were, fighting for the Magna Carta. Now the Magna Carta was written in 1215. Here they were fighting for the Magna Carta in 1775, 1774, 200 odd years. Okay, here we are now 200 odd years again away, fighting for the same thing that they fought for 200 years ago, or wanting to fight. Not even pre-revolutionary war, if there's going to be one. Hopefully, it would be nice to have a civil understanding between the government and ourselves. But the jumps were, they did not forget the Magna Carta. And now I am not forgetting the Magna Carta, nor am I forgetting the estate and the preamble. So time comes down to just, the argument just happened yesterday, as far as I'm concerned, with the Founding Fathers and the Magna Carta in 1215. Everything was just like it was yesterday. To me, I've reduced time to a very short period of time. But the statute of uses, again, or the statute of charitable uses, relief of aged, isn't that Social Security? Do we say, okay, the relief of aged, impotent, and poor people, that is definitely, absolutely Social Security. Okay, if you can relate to something and it starts looking like it, it must be it. As far as I'm concerned, the statute of charitable uses is the English Social Security, form of Social Security. There may be a section somewhere around here where it shows that taxes in England are for charitable uses.
Marriages and poor maids.
Yes.
One of the other areas.
Did you happen to see it?
Yeah.
Okay, it's for houses of corrections. Okay, tradesmen. Here we could have employment. The redemption of prisoners. Here we have our prisons. The ease of any poor inhabitant. Here we have all our socialized benefits, our socialism. Okay, comes from the statute of uses. So here we can look at the 14th Amendment and say it must involve a charitable use, a charitable trust. Yes, it does. Okay, let's pass on. Okay, if we look at the 14th Amendment is beginning to look like a charitable trust. It is. Now on page 451 we go into Mortmain. The English Mortmain and Charitable Uses Act. Oh my God, they just right in together. There's a little marked section in the footnote of that. It says a charitable trust may be created by will, by the incorporation, by reference into the will of the resolution, declaration, or trust agreement executed by a community trust if such instrument is recorded in the office of the Secretary of State. Okay, whatever happens in small trust happens in our trust, in big trusts, okay? Now, when we look at the 14th Amendment, we found here that we could not name the heir. The 14th Amendment names an heir. It names the heir. But it doesn't do it here, it does it over here. So here we have a separate estate that is lessened. We have a life estate that only is good for your life. It cannot pass on to an heir. And it is a trust. We're beginning to establish that it is a trust under the charitable uses. And let's try to skip on, because I think I'm going to have to have a break shortly. I wanted to see if I could find Cypress. Now, under charitable trusts is where CPRE comes up. And what CPRE means is that somebody has the ability to change the trust. In England, the king could change the trust, or the Lord Chancellor. Okay? But the Lord Chancellor only had limited capability to change the trust. He couldn't do a lot. He could only do a little bit to a charitable trust or to any trust. The king had ultimate power. In the United States, the Congress did not have see pray power. It was not given to them. It was not one of the prerogatives given from the crown. And it is a prerogative. It's the parens patriae prerogative, meaning parens patriae, mother of the country. Okay? The state has parens patriae power. The states. And charitable trusts fall under the see pray power, and I'm trying to find this.
You said that the government had no secret power?
The United States government has no see pray power. They exercised a power to that was resembled that. I'm trying to find it in the court case, the Mormon Church court case in the latter part of last century. Bogert here says that the United States government did not have it, but they exercised something that resembled it in that particular case. He goes into governmental trust on page 162. Hopefully we'll oh, here we are on the next page. Yes, okay. Section 432 on page 321. Judicial and prerogative cypress powers. Sometimes I say cypre, sometimes I say cypress. In England, a distinction has been drawn between the cypress power, which is vested in the Court of Chancery and is exercisable by it usually through a master, and on the other hand, the cypress power vested in the Crown as a parens patriae, also known as the prerogative power, which is exercised by the sign manual, etc., at the suggestion of the Attorney General. The power of the court is almost always based on the existence of a charitable trust, okay, or of an absolute gift to a charitable organization. The royal power is exercised in several cases where there is a gift for charity without a trust. That's the royal power. Basically, what I'm trying to get at is when Congress applied the cypress power to the Mormon Church, or what appeared to be the cypress power, they took a power that they didn't have the ability to change a trust or create a trust. It applies to this, okay? The 14th Amendment was already in existence, but they didn't have the power to create a trust. So they snuck a little bit of it, took it, the cypress power. They didn't have the power, only the states had it. So they, well, let's see if we can sneak it through here, and nobody will look and nobody will notice, and then we'll get some clear footing here and create the Federal Reserve Act, the trust, funds, and the Social Security Act, and whatever they were going to create in the future, because they're at least 20 years in advance knowing what they're going to do. Okay, page 332, the doctrine of cypress is a doctrine of prerogative. This comes straight from the Crown. When the King signed the Treaty of Peace, he gave the states, the people of the estates, the prerogatives of the Crown. Of course, Congress did get some, but not all. Cypress is enforced in some states. In the states where cypress is not enforced, the failure of a charitable trust gives rise to a resulting trust for the settlor or his successors. So we're talking about the creation, the manifestation of a trust. And Congress, on page 335, it shows you that 1890 was the Mormon Church incidents where the Supreme Court seems to have sanctioned the use by Congress of something like the prerogative cypress. Right there, they broke our trust. They created a second trust, or gave them the authority to do so. Okay, they took the authority illegally by the cypress power, by exerting this power that they'd never had. Now, do you get the idea of what cypress means? Okay, you won't get it all at first because cypress is you know, like kind of scattered out there, and it's like a bee you're trying to grab a hold of. You kind of get it, but it's not really clear enough. And once you get that it's basically the power to change or create a trust, okay, then you're beginning to get it. But they did not have that power. Okay?
That would be for charitable reasons.
For charitable purposes. They had no power. The king alone has the power, which is the people. The sovereign heirs, okay? They alone had the people. The states had the parens patriae. That's why that welfare, state welfare, is the state's business. That's their parens patriae, sovereign power. Okay, it's a charitable use, welfare, state welfare. Of course, it comes from the federal government, but they try to hide that. Moving right along. Oh my gosh, are we going to get through this? Or is Okay. I feel like I'm rushing. Okay. We've hit trusts. We've hit charitable trusts. We're looking at the 14th Amendment as a charitable trust. Okay, or a trust having charitable attributes. Next, we have a few ditties on guardian and ward. 39 Amjor, 2D, page 159. My, what is this? A trust relationship between guardian and ward? Is a 14th Amendment citizen a ward?
What page is that? 159?
Yeah.
159, section 208. Okay, it has been said that in no relation except perhaps that of parent and child or husband and wife are the elements of confidence on one side and active good faith on the other more essential than in the relation of guardian and ward. The ward is frequently a minor and often so young as to be entirely dependent on his guardian. The guardian is sometimes the ward's father or mother, and if not, sustains a quasi-parental relation. The government itself is, in a sense, the supreme guardian, whom the individual guardian represents in its solicitude for the welfare of the wards. Oh, what wards?
Yeah.
Oh, you mean there must be specific wards? I doubt it. Guardianship, therefore, has been said to be a trust of the highest and most sacred character.
Oh, yeah.
Now, believe it or not, they are a guardian up here. It is a trust of the most sacred and highest character. They are also a guardian down here, guardian-ward relationship in the 14th Amendment area. Okay? Different effect and different rules and different principles. But they are still a guardian of our covenants and trusts and everything up here in the preamble of the highest character. This is parens patriae, okay? As you notice on the side, it defines actually parens patriae. Now, down at the bottom, you notice that the confidential relationship immediately arises between a person-appointed guardian and his ward for the benefit of the ward upon the guardian's taking his oath, executing the required bond, entering on the discharge of his duties, and receiving as guardian property, money, or effects of his ward. These people have taken oaths. They have bonds. They have entered upon the duties. They are guardians. It is a trust. And when we get right down to it, these oaths, the oath is where God lies. And the bond is what needs to be attacked. Okay, next page, page 26. What they're discussing here are wards being infants or other incompetents. The heirs of the preamble estate are neither incompetents nor are they infants. They were sui juris and in their majority, meaning that they were of age 21 years old, they were citizens and therefore could vote. 14th Amendment citizen, on the other hand, is either or an infant or incompetent. That is what the 14th Amendment was created for. Infants or incompetents. Okay, continue on. Here we have things on infants and incompetence, protection and custody. Now we get into the parens patriae, which is attached to cypress. The state, through its proper organs, exercises its power for the protection of infants, since, page 20, since it, as parens patriae, is the guardian of the children within its jurisdiction. The federal government, however, does not stand in the position of parens patriae with reference to the persons and property of infants, except in the territories and the District of Columbia. The United States government does not have parens patriae power. The states have parens patriae. Oh, except in the District of Columbia and the territories. At this point now, yes, it is the states as defined under the Buck Act. Okay. But the states as defined under the Buck Act, which is found in Title IV. Okay. Once they statutorily define something, they change it. For example, employment has been statutorily defined under the Social Security Act. It is no longer the employment that we know it as here. Okay, it is owned, possessed, or ceded to. Once something is statutorily defined, the United States now owns it, or it has been ceded to it, is now fall within the corporate mortmain capacity. Boy, they've really shredded this country apart, haven't they?
Ye old shredder.
This poor woman here looks like she's about ready to cry or like, oh no, I didn't know all this. It gets overwhelming. You know, what they've done looks overwhelming, and we really must try to we know what they've done. Now we know really what they've done. You know, it's we're down to the nitty-gritty here. Again, on page 21, they bring into the discussion parens patriae. The state as parens patriae is authorized to legislate for the protection of care for the care of children under its jurisdiction. Now, when we're talking about infants, okay, we're also bringing in the incompetent people, okay, because they all fall in the same hat. Okay, infants and incompetents fall in the same hat. So this applies to them. Now, when you're an infant, let's see, the jurisdiction of equity over persons of property originated in the it originated in the prerogative of the Crown of England, okay, arising from its general duty as parens patriae to protect persons who have no other rightful protector. Oh, God, I don't know if I have another rightful protector. This goes into heavily what parens patriae is. Now, on the next page, on page 66 in section 65, you will see something that says liability for necessaries. This is a principle applied to the Social Security Act and your income tax and et cetera, et cetera. It is well established that an infant is liable for the value of necessaries furnished to him. If you're an infant or an incompetent, you're liable for the necessaries furnished to you. An infant's liability for necessaries is based not upon his actual contract to pay for them, but upon a contract implied by law. Have all you people been asking for the contract? You know, where's the contract that I signed that said I have to do this? It's right here. Because it is presumed that you are being supplied the necessaries of life to take care of an infant or an incompetent. Or in other words, a quasi-contract. Thus, an infant is liable for the value of necessaries if they are furnished to him under such circumstances that a promise to pay for them can be inferred. And he is likewise liable for necessaries furnished to supply his urgent need, even though he is too young to understand the contract for such necessaries. Next page, 67. The rule that an infant is liable for necessaries furnished to him was incorporated into Section 2 of the Uniform Sales Act, which provided that where necessaries are sold and delivered to an infant, he must pay a reasonable price for, although the comparable provision in the Uniform Commercial Code, voila, the UCC comes up, simply provide in part that unless displaced by the particular provisions of such code, the principles of law and equity and the law relating to capacity contract, etc., 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 he's bound by his contract. Right here is where you get the contract that the Social Security is upholding against you because you're an incompetent or an infant obtaining its necessaries. You will also find that in the next one under incompetent persons. An incompetent may become liable by way of contract implied in law for necessaries provided to his dependents or to himself. Next page, what are necessaries? The determination of what articles furnish an insane person, oh my gracious, are necessaries depends not merely on their nature but also on whether they are proper and suitable according to the circumstances and his condition of life. The term is not restricted to articles that are basically essential to existence, but includes all articles and services proper for the normal maintenance of the incompetent. The wants or needs of an insane or other incompetent person, which are personal to body and mind, are necessaries. Here you have all the necessaries in life being provided to you by the Social Security Department in a social welfare state. Do you see it? Do you see the necessaries being, that everything now can be construed as a necessary being provided to you as an incompetent person? Under this estate, are the building blocks building up from this coming down? Yeah. We also mentioned how a trust is terminated. There's no one inflexible mode for termination of the trust. We are all terminating this trust. When you apply for that Social Security number, you terminate this trust. You repudiate it. When you send in that 1040 every year, you repudiate the Constitution itself. That driver's license, everything the laws have been set up to do, force you to repudiate the trust. Now on page 388, we're going to go into spendthrift trust and similar protective trust. Now, the Federal Reserve Act, I tried to find the tape, somebody way back when the Federal Reserve Act was passed, some prominent person said that this creates the largest trust ever known on the face of this world, or earth, or something to that effect, and I couldn't find the tape as to who said it.
Yeah.
Oh, it was you. It was in your tape then.
Probably.
'Cause it was,
McFadden?
Yeah.
okay, that creates the trust. Okay, the 14th Amendment per se did not. It created a life estate which diminished this estate. Now, in my perception, the Federal Reserve Act, in conjunction with the Social Security Act, diminished the estate one more time. And I perceive it a possibility to be a lesser estate and one that is not a freehold estate. Even the 14th Amendment is a freehold estate, but it is a life estate. Okay? So now the estates are becoming diminished and more restriction is being placed on us, and we're going back into feudal times and servitudes and serfdoms and slaveries as the estate is being diminished, because that is the only way it can go. It is going in that direction. It already has. And we're going to get into the spendthrift trust here because the 14th Amendment, the Federal Reserve Act under the 14th Amendment created a spendthrift trust for incompetents and infants who were wards. Okay?